How's it going, everybody? Welcome back to Lead Therapy, and I really appreciate you taking your time tuning into my video. Recently, a court ruled homeowners have a right to answer the door holding a gun. But my question is that a smart thing to do? A 3-judge panel of the U.S. 4th Circuit Court of Appeals that a homeowner has every right to come to their door holding a firearm. Furthermore, doing so was not automatically justified for police to use deadly force against a homeowner. The case Knibbs versus Momphard stemmed from an April 2019-2018 incident where Michael Knibbs was shot and killed by a North Carolina sheriff deputy who failed to properly identify himself, both verbally and to allow visual confirmation of his office. The officer tried to make contact with the Knibbs household while investigating a potential misdemeanor crime. At the front door as he knocked, the deputy heard the sound of a shotgun racking. The deputy, using poor tactics, retreated to the corner of the porch and shined his flashlight into the front porch windows. There he claims he saw Mr. Knibbs pointing a shotgun in his direction. The deputy then opened fire, killing Mr. Knibbs. However, forensic evidence showed Mr. Knibbs was almost certainly not pointing the shotgun at the deputy, and Knibbs' wife said her husband expressed skepticism that it was really a police officer outside when he initially accessed the shotgun to defend his home from the decision to protect himself, his wife, his daughter, his son, and his infant grandchild. Knibbs armed himself with a shotgun, loaded it, and stood at the front door with the barrel safely pointed towards the ceiling. The person outside then shouted, "Drop the gun," and seconds later shined a flashlight on him and shot him. Knibbs never made any verbal threats or movements with the shotgun. He was shot simply because he was standing in his living room holding a shotgun. The court held that the deputy's use of force was objectively unreasonable. The appellate court also stripped the deputy of his qualified immunity protections. Once more, the decision bolsters an idea that if police fail to identify themselves, both orally and with visual confirmation, they will likely lose their qualified immunity, especially if they shoot first and ask questions later. While this case may strengthen a homeowner's right to arm him or herself within their dwelling, that doesn't mean a prudent person will answer the door with a gun in their hand, nor having windows beside one's front door that aren't covered with some type of window covering or sheer fabric to prevent someone from outside the home, whether it be a police officer or a bad guy, from easily looking inside and potentially shooting through said window. If you think you need to hold a gun while answering the door, do you really need to go to the door at all? And the answer is no. And that's where I want to get your guys' thoughts on this story. And if you'd please take time by helping the channel out, by liking, sharing, and subscribing and hitting those post notifications. And I'll see you guys in the next video.